This is the Know Your Law series by Barefootlaw, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Hello, my name is Daphne. We're still on the succession frequently asked questions under the Know Your Law series. I'm here with Timothy. He is going to share with us how to maneuver succession with regards to different customs in Uganda. You're welcome, Timothy.
Thank you.
So the first question is, how does the law deal with the fact that my culture does not allow certain people inheriting from the deceased?
In Uganda, as you know, we have very many cultures, and they are not necessarily in line with our law. So it is important to note that we have one main law in Uganda, which is the Constitution, and cultures are only allowed in as much as they work together in relationship with the Constitution. So where cultures go against the Constitution, they are considered to be repugnant and not allowed. So when you're thinking about your culture and how it can affect your inheritance or your succession, it is important to note that in some scenarios, your culture may not be followed. So for example, if in your culture a girl is not allowed to inherit land, then that will be considered an unconstitutional cultural norm because it is against the Constitution, which in its human rights provisions provides for equality of the sexes. And so when someone wants their property to be divided in accordance to their culture, they would need to put that somewhere in a will and specify who gets what and maybe even for what reason.
The Islamic faith stipulates how to share property by the family members. If I follow the Islamic model, can one of my children contest the distribution in the Ugandan courts of law?
That's a good question because we have very many different faiths in the country, and many of them have got their own methods for inheritance. And I think Islamic law is very good as an example because it's probably more specific than other religions that we have around. So it is important to note that number one, one's religion cannot dictate how their property is succeeded in terms of it being automatic. So if you die and you happen to be a Muslim, your family members can't expect that automatically that law will be applied. Because what we have when someone dies without a will is that we have the Succession Act, which provides for how to distribute the property of a person who dies intestate. So if you want to have your religious norms as part of the way that your property is inherited, then you would need to put it in a will and again specify who is going to inherit what according to your religion. That would be fine. But should someone die without a will, then it is not their faith that is followed, but rather the Succession Act that is followed.
How can I ensure my other relatives or extended family, as some may refer to it, do not steal my property, leaving nothing for my children after I am gone?
So this is something that is very common. We always see people from extended families encroaching on property of a person who has passed away, especially when the deceased person has got dependents who are not able to fight for their rights. And so it is important, if you are a person who has amassed some form of property and you have people who depend on you, whether it is children or elderly people, to write a will and state exactly what you need for them to inherit. And in this way, you're protecting them as well as your property and making sure that even if you were to pass away, those unscrupulous family members who will come and swoop in won't have much of a chance. Another important thing to do is if you have property like land, cars and the like, make sure that they're registered in your name so that when you pass away, it is not easy to say, use fraudulent mechanisms to claim that that was theirs or to try and transfer it.
What if the owner of the properties dies without a will and leaves children below the age of 10? Do the children only claim at the age of 18? And what happens between 10 to 18? What is the dynamic there?
All right, so when someone dies and leaves children below the age of 18, and if they're as young as 10, what happens is that because they don't have a will, there is going to be another person who has to apply for letters of administration to administer their estate. This could either be a spouse or another close relative or even a close friend. Once they have letters of administration, they are considered to be administering the estate on behalf of the beneficiaries. Okay. Now, young minors and children are going to be considered beneficiaries of the person who passed away. They are going to be, you can call them the wards, or the people who the administrator is expected to look after, especially if they were dependents. If those young people have got any challenges, then they would be able to get someone called a guardian, who is an adult that can represent them legally, especially if the administrator seems to be doing something shady with the property.
What can we do if our late parents' property is being sold off and we are denied access to the unsold property?
And this is if you're a minor?
Yes, this is if I am below the age of 18.
Okay, so great. So that is exactly what we were talking about previously, where you're a minor, you're below the age of 18, and the administrator or maybe the executor is using this property in a manner that is against your best interests. Okay. So in that case, the minor is supposed to, or is able to, sue whoever is either intermeddling or abusing the estate in the courts of law to get a justiciable outcome. The reason why they need to get a guardian to sue on their behalf is because in law, when a person is under the age of 18, they cannot themselves institute legal proceedings because they are not considered to be of majority age. So the minor would need to identify who can help them as their guardian to bring these cases on their behalf.
Can anybody, not biological, be chosen by a deceased person to be the heir? What does the law say about such an instance? So
in our law, we have two types of heir. First of all, we have the customary heir, who is the heir a person would have, customarily speaking. Okay. And then we have the legal heir, who is the person the deceased person chooses to be their heir, and they usually put that in their will. Now, when it comes to customary heir, they are already identified according to the customs. Mm-hmm. In some instances, I believe in some cultures, the woman's customary heir may be her daughter, the man's customary heir may be his son, etc. The legal heir can be a person that you choose. Usually people like to choose one of their children that they trust the most, but it can be someone who they choose to be their heir, especially if they don't have children. Now, the legal heir and customary heir can both exist at the same time. What happens then is that the customary heir will be in charge of all those customary practices that need to be done. They will call the family meetings, they will make sure that all the relatives are informed of what is happening, and the legal heir shall have the duties as assigned to them in accordance to the will, and they will be responsible for making sure that the procedure goes on until the executor of the will is chosen.
The next, what happens to those people that the deceased was looking after when he or she passes on? I'm assuming here these people are not biological, but maybe an extended family member, or yes?
Sure. So when a person is looking after people that they may not be related to, there is nothing wrong with that. Those people are still considered in succession law. So succession law does not just consider your blood relation, it also considers people that you're looking after. Okay. Those people are referred to as dependents. So if you are looking after someone and they happen to be a dependent, maybe they are living in your house or you're paying their rent, or you are in any other way giving them support, tuition, things of that sort. Should you pass away, it is expected that, and especially if you don't have a will, it is expected that your intentions were to continue supporting that person. And so whoever is chosen to administer your estate is expected to continue that support because this person is a dependent upon you. Yeah.
Another interesting one coming in here is, can parents inherit from their children?
Yes, as funny as it may seem, in some unfortunate instances, you will have a situation where a person who has been working for a while but looking after their parents passes on, and yet their parents were what we would now call dependent relatives. So relatives that are depending on you. And similar to what we just discussed, if a parent is a dependent relative, it will be reasonably expected that the person who has passed away intended on looking after these parents for the long term, probably until they themselves pass away. And so when an administrator is chosen for their estate, that administrator is expected to make sure that the estate continues to look after these parents or these other dependent relatives for as long as possible.
Thank you, Timothy. That's it for now. Hit the notification bell and you'll be informed on our next episode. We're still talking about succession, inheritance, wills, and all that. So if you have any questions, also leave a comment and we will get back to you. Thank you.